Welcome to Q&A, Social Security Disability Today. This program is brought to you by the Reeves Law Firm, representing you and your Social Security and disability needs. If you have a problem or questions regarding Social Security and disability, call attorney Anthony Reeves. Here's your host, attorney Anthony Reeves.
Why? Why does a representative need to know if I have appealed my denial? Okay. Depending on the case, if you're still at the administrative level, pretty much at each level, and let's say for most states there are 4 levels. You file initial application, you get denied once. You get denied this. You appeal that one as a reconsideration appeal, you get denied twice. You file a request for a hearing, you go before a judge, the judge denies you. You file an appeals, basically you file a request for review of the judge's decision. That's 4 times. So basically you've got, let me take that back, you got a recon appeal, a request for hearing, and a judge's appeal. Now, basically from the time you file your application to the very last part in the Social Security process within their parameters, you have 3 opportunities to appeal. Each one of those appeals requires 60 days in order to do so. In other words, you get denied on this day, you have 60 days to appeal. Almost every level of appeal going through is 60 days. While you're still going through the administrative process, it's important to know if you've appealed your denial. Why? Well, if a representative is talking to you for the very first time and you told them that you got denied, first thing they're going to want to know is when did you get denied? Because they're going to want to know if you're within that 60-day time period. If you're outside of that 60 days, they're going to say, did you appeal? Because if you didn't appeal, they're going to need to know 1 or 2 things. Why didn't you? So to see if there's a possibility of a good cause reason, or 2, to tell you that you need to start over so that this way maybe they can get the earlier application reopened. Now, same thing. If you've done those 3 appeals, you filed your initial application, got denied, 1 appeal. You've gotten denied a second time, 2nd appeal. You're going before a judge and you get denied, 3rd appeal. And then after you've done that, the agency, the appeals council, it's within Social Security, they deny you. Now you're going for them to make a decision and they deny you. The next level is to file in federal court. That means that 60-day window becomes even more important because there are things that need to occur during that window. Because here's the thing I tell people. If you're at the administrative level and you don't make that 60 days, Social Security can be accommodating depending on the reason. If it's a good reason, a lot of times they'll say, okay, we'll cut you some slack and let you keep on going. However, once you've gone through every level of appeal and you now have to sue the Social Security Administration, it becomes a lot tougher. At that particular point, they ain't trying to hear all that noise. You better have a really good reason for why you missed that appeal. So the reason why your representative or potential representative wants to know if you appealed your denial is because they want to make sure, 1, if you are within that 60 days, if they're going to do the appeal, that they get you the paperwork they need in time so they can knock it out. And secondly, they're going to want to know that if it's getting close to the time period of the 60 days, what they need to tell you to make sure you protect your rights, or what they're able to do to protect your rights. And thirdly, if you're beyond that 60 days, they have to determine whether or not they can actually go back and see if there's a good reason why you missed it so they can keep the case going, or whether they need to tell you that you need to start over. So that action of you appealing